Hook. All right, guys, buckle up, because this hearing takes a turn almost immediately. What starts as a routine request to represent herself becomes a tense showdown over sovereign citizen-style arguments, equity claims, and accusations that the court system operates like a bank. The judge is trying to conduct a standard fair-to hearing to determine whether the defendant knowingly wants to waive her right to an attorney. But the defendant keeps steering the conversation toward estates, administrative authority, and alleged due process violations. The big question is, does she fully understand the criminal process she's stepping into? Or is she relying on legal theories that have no standing in Indiana criminal court? Stay with me, because the judge's patience is about to be tested in a very dramatic way.
You indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty of 2 level 6 felonies? So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
This is the moment the hearing becomes serious. The judge carefully explains that self-representation is a constitutional right, but it comes with enormous risk. Notice how he lays out the potential penalty: 2 level 6 felonies and up to 5 years in prison. That is not a technicality. That is the reality hanging over this defendant's future. Her repeated response, "I copy," is unusual courtroom language, and it raises an important question. Is she truly absorbing the consequences, or simply acknowledging that she heard the words? If you were facing years behind bars, would you feel confident giving up a trained defense attorney?
Attorneys have developed certain skills in investigating your case, interrogating witnesses, and finding favorable witnesses and obtaining their testimony. They can explain the charges and any lesser included offenses to you. They can gather documents and other kinds of written evidence. They can prepare and file motions before trial, such as motions for a speedy trial, motions for discovery, motions to keep unfavorable information from being received as evidence. They know how to examine and cross-examine witnesses at trial. They can recognize objectionable and unfavorable evidence and promptly object to its use. They can present favorable sentencing information and attack unfavorable sentencing information. At a jury trial, they can present favorable opening and closing statements, prepare appropriate written jury instructions, and select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case.
The judge is now doing something appellate courts require, making a detailed record of everything an attorney could do that a self-represented defendant may struggle with: investigating witnesses, filing motions, suppressing evidence, negotiating plea deals, preserving issues for appeal. This is the judge's way of saying, I need proof that you understand what you're giving up. Many people think representing themselves means they'll finally get to tell their story. But criminal trials are governed by strict rules of evidence and procedure. Do you think most defendants underestimate how technical a courtroom really is?
So comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close, different things like this. And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or um, processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that my ad in a
Oh,
high.
ma'am, that's not the question I
No,
asked.
no,
I think you misunderstood the question.
it's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain ever since when I had.
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you file with the clerk's office, what's the receipt date on this?
It should be April 16 or 15.
April 16th it was received, so just yesterday.
Mhm.
That these aren't criminal matters that you filed with the court?
Those are criminal matters, the violations that have been held against me. Yes, that's a lot of
You
violations.
understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under some
Yeah.
sort of a pseudo legal jargon. Some
Here's the turning point. The judge has reviewed the documents she filed and immediately recognizes language commonly associated with sovereign citizen or pseudo-legal theories, references to equity, estates, executive authority, and administrative settlements. He is trying to determine whether she believes those theories can override criminal law. When she asks whether this is an Article 3 court, the judge firmly corrects her and explains that Indiana state courts operate under a completely different constitutional framework. This exchange is critical because a defendant who bases a defense on legally invalid theories can seriously damage their own case.
My innocence of the matter, and also the violations, the due process, the unverified information, the lying, the evaluation. I've been forced to be drugged without a cell hearing. My evidence that was held from me when the what's his name? Jeffrey Clymer had ordered the prosecutor to meet me in private to see my documents. I mean, the evidence held against me, and he refused to present them to me. That's a Brandy violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Feretta hearing.
I know,
okay?
but you asked me, and I'm trying to explain the violations. Okay.
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have attorney.
I did that too. You know what he did?
I don't know, ma'am.
Ignored me.
What you have filed through the clerk's office, you're saying are that matters in equity. We don't recognize what you're talking about in
You
these
asked,
filings.
this is a bank. This is a bank. I understand how the
What'd you
court-
say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system doesn't
operates.
operate like a
Yes, it
bank in any way whatsoever.
I
So-
hold on, let me finish.
No, I'm not gonna let you finish that
Okay.
particular
Like
statement.
I said, I want to
because
preface
I
this.
just
Don't
need-
want to argue
I need you
anything.
to,
I just want you to
redirect-
understand me mentally.
I did the mental thing just fine. I'm not
Okay.
worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
This is the jaw-dropping moment of the hearing. The defendant lists alleged Brady violations, forced medication, withheld evidence, and due process concerns, claims that, if properly raised through legal motions, could be significant. But then she pivots and says the court system operates like a bank. The judge immediately cuts that off and draws a hard line. This is not a commercial transaction, not a court of equity, and not an administrative settlement process. You can actually hear the judge trying to separate potentially legitimate constitutional complaint from arguments that have no legal basis. Who do you think handled this exchange more effectively, the judge or the defendant?
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
Yes.
Will you do that?
Yes, yes, yes.
You will do that.
Yes.
So you understand that what you filed yesterday can be stricken under the record. Under the trial rules, under Indiana Trial Rule 12F, because it's impertinent to anything that is going on in this proceeding. You realize that?
I understand that in a sense, but like I keep explaining to you, it was not supposed to be filed in the court. That's the difference.
You filed it at the clerk's office.
Yes.
Well, let's carry that out for a minute.
Yes, it's a difference.
What's the name of the clerk's office?
The court's office is the clerk of clerks. Clerk of clerks.
Clerk
Yes.
of courts, right? So there are
Yes.
clerks. So if you
Yes.
file something and you have a case pending, they send that to your case. Unless you try to open a case of your own,
No.
you're trying to open litigation of your own.
No,
Okay.
what I am.
This has to be presented in your court case here that you have pending before us.
Okay,
you're
so you
telling
will
us
not
to
strike
follow
it?
the rules.
You won't strike it down or you will strike
Oh,
it?
it has to be stricken. It is impertinent to anything we're doing here. You understand?
No, I don't understand.
Okay.
how You
You
just won't
have
strike-
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay,
You realize
But-
that?
but let me explain, can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
What I also want to say something, and I also am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive.
As the hearing closes, the judge makes the key ruling clear. The documents she filed are considered irrelevant to the criminal case and can be stricken from the record under Indiana Trial Rule 12F. Even after that explanation, the defendant continues reading a declaration about being a living man and reclaiming an estate, showing that the court and the defendant are operating from completely different understandings of the law. The judge's goal was not to debate those beliefs. It was to determine whether she could follow Indiana criminal procedure if allowed to represent herself. This hearing became a powerful example of how self-representation can quickly collide with the rigid structure of criminal law. If this courtroom clash shocked you, drop your thoughts in the comments. Let us know who made the stronger case, and subscribe for more explosive courtroom breakdowns and legal drama.